Well, for a little bit more on this, we're now joined by Labour analyst Jonathan Goldberg. Thanks so much indeed for joining us. Good to talk to you, Jonathan. Good to see you again.
Good evening, Peter, to you and your viewers.
All right, so let's start with what this Labour Appeal Court order means. If the workers don't return to work tomorrow morning, what does that mean for them?
Well, the Minister reiterated, which is quite comforting, that they have faced misconduct and that there will be misconduct inquiries, which could lead to dismissals. But remember, notwithstanding the Labour Appeal Court decision, effectively, if you're an essential service worker, so defined by the Act and by the Essential Services Committee, further to that, then effectively your strike is unprotected and they committing misconduct in any case.
All right, so
without the court order.
All right, so a whole process then takes place with each worker individually, and they could lose their jobs as a result.
That's correct, Peter. And again, obviously, there's other acts of misconduct that have taken place, widely reported by your news channel and others, where people have blockaded, barricaded other people from coming to work. Also, people have been assaulted, property has been destroyed. And we hope that the ministry then follows through to take action against those people who've conducted themselves in such manners.
All right, put us into context where the Labour Appeal Court fits in the scheme of things. How high up the food chain is it? Is it the same level as the Supreme Court, for example? Or if they're not happy, where do they go? Do they go to the Supreme Court? Do they go to the Constitutional Court? Where do they go?
Well, it's second highest, similar to other matters where you get the Supreme Court of Appeal. In Labour matters, you get the Labour Appeal Court, and then you can go to the Constitutional Court. But seeming from earlier press releases and interviews, Nehawu is going to abide by this Labour Appeal Court confirmation of the Labour Court decision, and they would encourage their members that are, remember, it's only their members that are part of the essential service that cannot go on strike, that need to have their dispute resolved elsewhere, that those particular employees are then instructed to go back to work. Going back, Peter, I think it's important for viewers to understand that in terms of our Labour Relations Act and in terms of the Constitution, of course, strike is in terms of our Constitution, the right to strike is enshrined in the Constitution, but that's limited to what's fair and free in an open and fair democratic society. And that's contained in the Labour Relations Act, where certain workers, like health workers, not the cleaners, and other people ancillary to that, are then barred from striking, and their matters must be resolved by arbitration. So that's all in terms of the law, and that's why these employees should never have gone on strike, who are defined as essential service. Other employees who are not defined may go on strike. It will be then a protected strike, and they can are free and fair to exercise their democratic right.
We've heard of loss of life that can be directly attributed to the strike. Does that mean that there could be potential liability in terms of a family whose loved one may have passed to say, hang on, had you not been on strike, my loved one would still be alive, therefore you're liable for that death?
I think there's criminal and civil liability. I think they're both. And that's why the state must act decisively. I think we as citizens of South Africa must ask the state to uphold the law in labour relations and these kind of matters like strikes. Over years and years of employers, including the state and municipalities, not enforcing the law, not abiding by what is fair and balanced. In other words, you can go on strike if you're not an essential worker, but that strike must be free of violence and intimidation. So many of our strikes are not fair and free. They have huge intimidation and violence taking place, and that clearly is not what the Constitution envisaged as a free and fair democratic right to strike. And I think it's high time that this goes through the courts, where courts, right up the Constitutional Court, declare that when violence and intimidation gets to a point within a strike, that strike loses its protection.
All right, so I'm just wondering now, going forward, I think you mentioned arbitration as a solution for people who are essential workers. Who then would be the arbitrator?
Well, again, it would be a bargaining council in this case. They're governed by a bargaining council, arbitrator. And I'm a big fan of arbitrations before strikes take place. So even in non-essential workers, I don't know why we've got to go through a 2 or 3 year violent strike where we cause huge damage to the economy, huge damage and destruction to machinery or equipment or buildings or trucks, as an example, instead of going to arbitration where effectively an arbitrator hears evidence and then decides on the respective parties' presentation of the evidence what a fair increase should be. So I think we need to introduce, parties need to be mature enough in many strike situations beyond essential services to embark, if you're really concerned about jobs, the economy, growth, security, safety, stabilization of South Africa. To my mind, we need to get much more involved in the parties agreeing to arbitration where they've reached a deadlock.
All right, so we've got two groups of people here. We've got essential workers and non-essential workers. If the essential service workers go for an arbitration and they're given 5%, does that then become something that the non-essential workers have to abide by, or do they go through their own negotiating process and they might get something else?
That's a very good question, Peter. In terms of the law, they'd be able to continue to strike until the employer and the employees, represented by the trade union, negotiate a deal. If I was the employer in those circumstances and I got an arbitration award at 5%, I would then capitulate with the rest of the workers in terms of saying, clearly, I wouldn't want to have more damage. 5% seemed to the measure that people will go on strike on and keep on being on strike until they achieve that particular result.
Jonathan, we seem to see what's happening now happening quite frequently. I'm just wondering if this Labour Appeal Court judgment doesn't set a precedent that in future people are stopped from striking if they're not allowed to strike, or do we have to keep going to court every time?
What sets a precedent is the employer, the state here, taking decisive action against workers who contravene the law and workers who misconduct themselves in committing acts of misconduct. And remember, many of these acts of misconduct are criminal. So they should be charged internally and charged in the criminal courts in regard to the actions, because assaulting people, including patients, one clip I saw today, are criminal offences. And clearly, you can't have those kind of employees working in an environment, in any environment, let alone an environment where our duty is to protect patients and care for patients in a situation where the patients are in dire straits. You don't go to hospital and medical facilities if you are fine. You go there when you are already at the lowest point in your life. And we as South African citizens deserve more and should demand more. And in those circumstances, it's the way the government acts to this. It's the way that municipalities, state-owned enterprise and private businesses act in regard to upholding, one, what is the law, and two, what is good practice in terms of rules and regulations in an organisation. That, to my mind, sets much more of a precedent going forward than a Labour Appeal Court decision, which is it just restates the obvious, that essential services workers in this sector cannot go on a protected strike. Their strike is unprotected. It is misconduct. The strike itself is not necessarily criminal. It's not criminal unless the conduct of the workers overreaches that particular barrier of criminality.
Jonathan, we'll leave it there. Thank you very, very much indeed for joining us. Your insights greatly appreciated. Thanks for your time.